Good evening. This is Rahul Reddy. Along with me is my business partner, Emily Neumann. Every week on Tuesday from 5 p.m. Central Time to 6, we do live shows. We update immigration every week from past 4 years. Emily, what do we have today to discuss?
Today, we want to talk about, the H-1B lottery results are in. So what are the alternative options for those that were not selected in this year's lottery? What are the possibilities of a second round happening this year? We also want to talk about a rumor that's going around that says that H4 visa holders can work in the U.S. even if they don't have an EAD, based on some outcomes of recent litigation. I think people are misunderstanding what exactly that litigation did. So we want to separate the fact from the fiction there. A lot of people are talking about converting to a B1 or B2 visitor visa when they're ending nearing the end of their 60-day grace period on H1B or on L1. So we'll talk about that change of status process, what it looks like, and what potential pitfalls are there so you can avoid them if you decide to go that option. And last, a lot of people are asking about the EB1 green card option because obviously EB2 and EB3 is becoming more and more backlogged, and EB1 is one of the few that has some relatively available visas. But what are the different types of EB1 green cards? There's EB1A, EB1B, and EB1C. What are the differences? What's the theme, and how does that process work? So we'll start off with the alternative work visa options for people that are not selected in the H-1B lottery.
Emily, there are almost 30 options available there. I will quickly read them. L1 visa, E2, O1T, and E3, F1, J1, H2B, H3, P1, R1I, Q1, EB1A, EB1B, EB1C, EB2, EB3, EB4, EB5, H1B1 for Chileans and Singapore's, E1, E4, T1, U visa, H2A, H4 EAD, F2, L2, J2 dependent visas. There are a lot of different options available for the people. However, we cannot cover all those things. Mostly people are not eligible for most of the things. We're going to cover the main topics. However, Emily, when are you doing a webinar for the people who are not selected and they want to speak and get into more detail?
Yeah, we're going to be doing a deep dive webinar on this exact topic on Thursday. Myself and Stephen Brown, who's the managing attorney of our non-immigrant visa team here at Reddy and Neumann. And so that's going to be Thursday afternoon. And we do have the link for where you can register for that in the comments. You can also find it on our website at rnlawgroup.com. So please join us there to get more information on each of these options, which ones are actually available to you, which ones are good, and which ones may not be the best.
First thing is that I will tell people is that if you have H4 EAD options, take it. You may want to consider looking into O1 visa if you're eligible for. Some of the companies, Emily, they're offering, okay, why don't I transfer you to Canada for 1 year? And then maybe I'll bring you back on H1B when the next year quota comes in. Or probably they will try an L1B option also, which seems to be a good option, though. If companies have branches elsewhere, you may want to consider it, because if you move on to visas that does not allow you to work, definitely it's not a good thing. But if you go to outside the country, you have an option. You can still come back on H1B. They can still file because you're still in the loop with the company. And yes, L1B will be an option to the company, and you are qualified for it. Any other options, Emily, that these people who are not selected in the lottery?
I think one that maybe people aren't aware of is the cap exempt H-1B option that actually allows you to work concurrently for a cap subject employer without going through the lottery. So if you can find an employment with a cap exempt H-1B employer, once you have that secured, that can be filed any time of year. There's no lottery, there's no waiting period or anything like that. Then you actually can have your regular employer who sponsored you in the cap where you weren't selected file a concurrent H-1B to allow you to work for both companies at the same time, both the cap exempt and the cap subject. And you don't have to go through the lottery to do that. And that can maybe get you 1 year. You can do it for up to 3 years, but then you can try the following year in the lottery to at least buy some extra time there by working those 2 jobs.
Emily, what about O1 visa option that we discussed previously? What is O1? I mean, if somebody is exceptionally good, can they apply for O1? Like, for example, if somebody is a scientist and, I published a lot of papers, is there something called O1 and they can use that?
Yeah, it's meant for extraordinary ability, so it's kind of similar to the EB1 green card option. There's a list of 10 criteria, and you have to show that you meet at least 3 of those. And it is meant for kind of the cream of the crop, the top of the field. But it is something to look into, especially if you have a PhD or if you're a researcher and you were not able to get in the cap. That may be a good backup plan if you've got that level of skill.
Emily, for the non-Indians and Chinese, is there any other options though, other than these non-immigrant visas that we discussed?
Yeah, I mean, if you are in the beginning of your OPT time, still have STEM extension time, you've basically got 3 years of OPT, you may be able to avoid this lottery completely by going straight to the green card process. So your employer can sponsor you for the labor certification, I-140, and because you're from a country that is not backlogged, you may be able to also file your I-485 and get the EAD through that. Which provides you work authorization by the time your OPT is expiring, and then you'll convert to a green card. So that would be a great option for someone who's got time left on their OPT that's not from a backlogged country.
Emily, I thought people are telling that on F1 visa you cannot apply the green card. Are they wrong or are you wrong?
We're both right. So there is a restriction that says F1 is a non-immigrant intent type of visa, meaning that you can't be intending to become an immigrant in the U.S. when you're applying for an F1 visa. That's at the time you're applying at the consulate and at the time you're entering the U.S. at the port of entry on that visa. But once you're here, you can change your intention, you can change your mind and be pursuing the green card while you're still on F1. It does not automatically end your F1 status just because you've started that process. We just recommend that you not travel while the green card process is going on once it gets to a certain point, because then it can be risky for you to re-enter the US.
Please don't forget that we have a seminar on Thursday. The link is provided at the bottom here. You can attend. We are going to take on questions live at that point of time. It's going to be easy for you to have the options discussed with the lawyers at that time. Emily, let's move on to the next topic unless you have something else. There is a rumor that all H4 EADs are allowed to work with a court decision. And every week I'm getting another rumor. Headline news in India tells that you can work. You don't need to have an I-140. You actually don't even need to have an EAD. Once you're on H4, almost very similar to L2, they can work. Is that right or is it wrong?
That is 100% wrong. If you're on H4, the only way you can work is if you have the H4 EAD, which you can only get when your spouse, H-1B spouse, gets to the certain point in the green card process and has that I-140 approved. But yeah, the H4 EAD was in the news recently due to some very long ongoing court litigation that was actually trying to end the H4 EAD. And in the final decision, finally, the court agreed that the H4 EAD should continue and can exist, and it was properly created. So yes, H4 spouses can work when they qualify for the EAD and receive the EAD through that regulation. But a lot of people are misinterpreting it. There's lots of articles out there saying, oh, this actually says all H4s can work. And that's 100% not true. If you're in the US in H4 status, if you want to work, you have to have an EAD or you've got to change your status. There is no automatic work authorization for H4 holders like there is for L2 or E dependents.
Now, please, guys, there are getting too many of these things coming up nowadays. Emily, recently the rumor came out that H-1Bs can be unemployed for a period of 180 days, which turned out to be not true. So these rumors are spreading out a lot. Every week, something or the other thing is coming. I tell people to tune on to the news that comes directly from lawyers. That's better so that you can evaluate it much better. Emily, what about people who are nearing to the 6 years of H-1B? These are the people where they have not filed a labor or I-140 application until now. Their labor is pending or they're expecting their labor to be approved soon. When they convert into B1, B2 option, what are the things? Can they work on B1, B2? That's another rumor that came out. Remember, Emily? Can they work on?
No, definitely not. That visa is not for working at all. It's for visiting for pleasure, tourism type of things, or business. But there's a very fine line between what is business and what is work. And so you need to make it very clear that once you end your H-1B and have the B1 or B2 pending, you're not allowed to work during that time. And the other thing to think about is the B1, B2, it's also a non-immigrant intent type of visa. So you should not be having the intent of being a permanent resident while you are processing that visa. That is something that can come up, particularly where we see it is, if an I-140 has already been filed in the past and maybe withdrawn, or you've got the I-140 pending, but it's not approved quickly enough for you to get the H-1B, that can be a risk for converting to the B1, B2. The other issue is the timing, because those take so long to be approved. When you apply for that, you can only ask for 6 months, but the processing time is a year. And so some people think, well, as long as it's pending, I'm fine to remain in the US. And that's not true. You can only stay until the time you have requested or until a decision, whichever is earlier. And that can also, the timeline of it, the processing time can make it problematic for later converting back to H-1B when you don't have a decision yet on your B1, B2. You have to ask USCIS to basically process the change of status to B1 and the change of status back to H-1B at the same time. And they're not great about doing that. So it may result in you having to exit the country, get the visa stamp, and come back to get back to H-1B.
But there are other alternatives, guys. For example, if you have a H4 EAD, definitely that's a better option than B1, B2. You may want to consider F1 option too. That's available too. You may want to consider leaving outside the country, because if you don't want to interrupt the employment, you can go outside the country and continue working for the company. Even though you don't have a H1B, you can go to your home country and work. You have legal authorization to work in your home country. So you can do that too. Sometimes what happens is that when you leave the employment, the employer may discontinue the green card application. And that's a very serious thing for you, is if that happens, you may not get anything and then you have to wait for the lottery again. So consider leaving the country and then coming back on H-1B after the I-140 is approved. Can the company process the labor and I-140 while you're outside the country? Absolutely, yes. They can do it while you're outside the country. And once the I-140 is approved, you can resurrect the H-1B and come back into the United States. Anything else, Emily, before we go to the next topic?
Next topic. So there's all these different EB1 options, EB1A, EB1B, EB1C. Are they treated any differently on the visa bulletin, or do they all just fall under the same EB1 category? How does that work?
A, B, C, even though the grade is very good, and some people it's not good. For the category of the EB1, no. Everybody is equal for the visa numbers, whether you are an Oscar Award winner or you are just a multinational executive manager. You come into EB1 category. There is no EB1A, EB1B, and EB1C. However, when you are applying for the green card, though, you have to specify under which category that you are applying. Now, each qualifications are different. For EB1A, you need to qualify out of the 10 extraordinary things, you need to qualify at least for 3. Of course, as a lawyer, we always try to shoot at least 6, because you know that we're going to get shot by the USCIS sometimes. So you should try to shoot for EB1A. If you are out of 10, you need to. But when it comes to EB1B, it's a little bit lower requirement is there than EB1A. However, this is for outstanding researchers. So for it may not be applicable for a lot of people, especially who are doctorates and who are working on the research. Now, you don't have to technically be a doctorate person to work to get the EB1B, but as long as you're in the research field doing a very outstanding research, definitely you may be qualified for the EB1B. The EB1A can be filed by the company EB1A can be filed by yourself. It's self-sponsorship is allowed in EB1A. When it comes to the EB1B, only the organization can file for the EB1B. The organization should also have some qualification. For example, they should have the research wing, and they should have other researchers working for the organization. That's a requirement for the EB1B. Now, for EB1A, that may not be the requirement. For EB1B, that is the requirement that the company has to be in the research field, and there are other researchers, and only company can file for the EB1B. When it comes to the EB1C, most of the people are aware that you must be a multinational executive or a functional manager, which is a very tough criteria, functional manager. But Emily is going to describe more and on the EB1C and discuss more on the EB1A and EB1B, whatever I left out, I guess.
Yeah, so for the EB1C, this one does require employer sponsorship. And I think some people get confused thinking, well, I'm a manager here, that's all I need. No, it only works if you are a manager outside the US and then are being offered a job as a manager in the US by a related company to the one that you had outside the US. So most people in that situation would have come on an L visa. So if you're on an H-1B, you may have to actually exit the US, work outside the US as a manager for a year, and then come back into the US to be eligible for EB1C. So it's not just based on the fact that you have a job now that's a manager. It has to be also a job that you had outside the US for at least 1 year. So that's something to remember. And then the company outside the US and the company inside the US have to have a qualifying relationship. They have to either be parent, subsidiary, or affiliates with shared ownership of some sort. And then there are 3 different ways technically to qualify for EB1C. One is if your US position that you're being offered is the executive level. The other is managerial of a people manager, and then the other is a functional manager. So it's very important to know that just because you're called a manager, USCIS does not automatically assume that you qualify for the manager level position. They're looking at your actual job duties. Are you spending a substantial amount of your time, the majority of your time, doing managerial level duties, not doing the job yourself? So they are going to dig deep into the job description, look at the percentage of time you're spending on each duty. Now, for a people manager, the types of duties they expect to see are that you're involved in the hiring, firing, promotions, agreeing to leaves and vacation time and all those sorts of things, and that you're spending your time doing one-on-one meetings with your direct reports, that you're doing performance reviews, and documentation of all of that has to be submitted. Whereas if you're a functional manager, you have to show that there's a function of the company that is critical or essential to the company, and that you are operating at a high level with respect to that function. And then on top of that, that you have other people that may not be directly reporting to you because you're not a people manager, but there are other people in the company that can carry out the day-to-day activities of the function while you are just managing it. So that can be a very fine line there. And again, USCIS looks very deeply into the job descriptions. And also they always want corroborating evidence, some sort of supporting document to show that you're meeting all of those requirements.
Emily, nowadays with the EB3, EB2 is not coming at all, people are considering going to other countries, working for the same company for which they are working, and come back though. Do they just, by working there for 1 year as a manager, by coming back, what are the hindrances? What should they look into though? Should they take the advice before to see what the position meets the requirement, or just go there and try their luck and come back?
Yeah, I would definitely recommend getting some detail about what exactly the job is going to be outside the country. What is your team going to look like? If you can come up with what the organizational chart will be for your team, how many direct reports you'll have, what are their education levels? That can be an issue. If you're a first level manager, you have to show that the people reporting to you are all professionals. So you may have to get their degree certificates to prove that. So you'll want to make sure that someone takes a look at your organizational chart as well as the job description before you make that trip. because you don't want to spend a year outside the country to only find out that really the job that you were doing for that 1 year doesn't really meet the definition of manager. It is a very specific definition. There's 4 criteria for it, and you have to look at each one to make sure that it will qualify. So I do recommend getting in touch with an attorney before to see if that might be an option for you. And another thing that people aren't really aware of is that nowadays with remote work, I mean, people are managers of people all over the world. And so it's okay if you're in the US and some of the direct reports that you have are actually in another country. We do that all the time. They raise the question from time to time, but it's never a reason for denial, because where your direct reports are located is completely irrelevant. It's not part of the regulations. There's no requirement that you only be managing US employees in order to qualify as a manager.
Is there extra scrutiny, Emily, when people are just going, they're here on H-1B, their labor certification has been filed, I-140 is approved, now they're going to India and coming back within 1 year? Will there be extra scrutiny as compared to the people who have been working for a long period of time and coming on L1A and applying for the green card?
I've not had that experience, and I don't think that would be likely to occur. Yes, it might seem odd to someone that they would be in the US for such a long period of time and then leave for just 1 year and come back. Obviously, their intention is to get into the EB1 category when they do that. But USCIS doesn't care about what your intention was when you left the US and why you're coming back to the US. As long as you were there as a manager and are coming back here to be a manager, the fact that you're doing it to change your green card category is completely irrelevant.
I'll go to question and answers. A question that comes is that my friend applied H-1B last year with the company. Currently, the status is off in RFE. This year, the new H-1B applied by company B selected in the lottery. If company B application petition, will it get an RFE again? Just because you got an RFE previously, though, that doesn't mean that it's going to get an RFE right now. What I don't understand, Shailaja, is why have you guys not converted into premium processing the company A's H-1B? Now, people will say that, oh, if you convert into premium processing, you are going to get the RFE. Well, you got the RFE anyway. You didn't convert into premium processing. So definitely that is not true. You should convert company A's into premium processing and get it out. I mean, either way the result. But just because you got an RFE from company A doesn't mean that you're going to get an RFE from company B.
Robbie says, can I convert my H-1B to B2 when my H-1B is maxing out? Is that a good option? And do I need to apply when I'm outside the USA? So yes, it is one option. There are probably better options. One of the ones to consider would be taking trips outside the US during your H-1B time, particularly if you go to your home country. You can work remotely from your home country for, as long as you need to, and then buy enough time for your perm to be processed, your I-140 to be approved, so that you can come back on H-1B. So that way you can be working the whole time and still be able to wait it out to get that I-140 approved so that you can extend beyond the 6-year limit. Another option, if you have it, is to convert to an H4 EAD or an H4. But if you're doing just the H4, you don't have the option of working, so you'd have to stop work for that. Same thing with the B2 change of status. You'd have to stop working once you run out of your H-1B time. And then the difficulty, you don't have to leave the US to do that. You can apply for a change of status from H-1B to B2 as long as you file before your 6-year limit is reached. The problem is, by the time you get your I-140 approved to be able to convert back to H-1B, your B2 might still be pending. So your H-1B might have to go through consular processing, have you exit, get the visa stamp, and then come back. So that's just one thing to consider. But it is an option if you're nearing the 6-year limit. But it'd be better to go outside the US during your 6 years so that you can recapture enough time to get the I-140 approved.
Sharda has this question. Is it mandatory to approve the H-1B, H4 and EAD together? If you apply in premium processing, should they approve the H4 and EAD together? My attorney is saying, no, it's just a courtesy. No, they're wrong. There is an agreement between the USCIS, and of course, we are the lawyers for the agreement. That was a class action. That's you are involved in it, irrespective of whether you paid us or not. You are involved in it, and it's applicable for you too. You can thank us for it. They have to approve it. Now, there are some rare cases. They sometimes are not approving it. That's because it is the lack of understanding by the officials. When we contacted the USCIS attorneys, they said that they're going to work with the low-level employees to make sure that the H1, H4, and EAD are approved at the same time. Ankit from YouTube has this question, a very interesting question, Emily. I want to listen carefully. Can somebody apply on H4 EAD? Can they apply for the I-140? The answer is yes. You can apply for the permanent I-140. Now, his question is that once the I-140 is approved, are they not exempt from the H-1B lottery because I have an I-140 approval? I don't have to go through the H-1B? No. The answer is no. Just because you have an I-140, no, you will not get an H-1B. For you to get the H-1B, either you go to the CAP exempt, which are CAP exempt organization, or you have to go through the lottery system. Just because you have an I-140 approval, you are not bypassing the lottery.
Karen says, I'm on H-1B and expecting my I-140 approval soon, and my fiance is on OPT F1 until May, May of this year. Assuming the H-1B is not selected, how can my fiance switch to H4 and H4 EAD with minimum impact on his job in the U.S.? Well, number one, you've got to get the I-140 approved first. So you may want to make sure that's filed in premium processing. Number two, you've got to get married in order for him to qualify for the H4. Now, once you're married, you can file the change of status to H4 and H4 EAD. But you're right, the processing time is long. And so he may run out of OPT time before you're able to get the H4 EAD and would have to stop work in that situation. However, if you can file an H-1B and then file the H4 and the H4 EAD along with it, and you're able to file your H-1B in premium, all three can be approved together, as we talked about earlier with that premium processing. Now, why would you be filing an H-1B if your H-1B is valid and you don't need to file an extension right now? If your employer is willing, they can file an amendment of your H-1B to allow you to file something along with the H4 and EAD in premium processing to be able to get that fast process for the H4 and EAD. It does require your employer's help and cooperation in doing that because they're filing an H-1B that they technically don't need, but that would allow you to get everything approved and minimize any gaps in your fiance's status before getting onto the H4.
Albert Berg has this question. I would like to, what does it mean by oath ceremony will be scheduled? This is about naturalization he's speaking about. How long does he have to wait for the ceremony? Mr. Berg, there are two kinds of USCIS offices. Though. In some of the offices, when you complete the naturalization, the officers have the authority to take an oath then and there itself and then give you the citizenship. About 50% of the officers belong to this particular category. I mean, when you go for the N400 citizenship interview, they will approve the naturalization and they will give you the citizenship. They will tell you to take an oath and that's it. They'll give you the naturalization certificate. You don't need to do anything. But there are some districts where, especially, for example, Houston, some districts where they don't give the officer doesn't have an authorization to take the oath and give you the citizenship, they will call you for the interview. Typically, it's anywhere between 15 days to 2 months is the time period that it will take for you to get the naturalization oath ceremony. And people ask this question, why is it different in Dallas, which they will give the green citizenship then themselves in Houston? It depends on the federal court judge. The federal court judge can say, no, I don't want to do this oath ceremony. You have the, I will give you the authority, I delegate the authority to you to take the oath from these people and then give the citizenship. Some of the district, federal court district judges will say, no, we want to administer ourselves the oath ceremony. So if you belong to the second category, which probably you are, then you have to wait for the oath ceremony where the judge will come and take an oath of you. But in the oath ceremony, though, unlike the 484 interview, it's just a mechanical process. You just go, you just tell your name, show your ID, just stand in there, listen to all the speeches. Yeah, it's really boring, believe me. Listen to all the speeches and you say yes and all those things, and then you raise your hand, you take an oath, and they'll give you the naturalization certificate. Yeah, I definitely prefer to be the first district rather than the second district where I have to go through all this oath ceremony process. But unfortunately, you are in the second district, second kind of district.
Tarun says, if my current employer agrees to not withdraw the I-140, do I still have to remain with them for 180 days after the I-140 approval? So there's technically no requirement that you have to stay with an employer for a certain amount of time after the I-140 is approved. What the requirement is, the employer should not withdraw that I-140 within 180 days of approval, because if they do, then you cannot use that I-140 to get continued H-1B extensions beyond the 6-year limit, and your spouse can't use it to get the H4 EAD. So as long as they're agreeing not to withdraw within 180 days and you feel comfortable that they're going to abide by that agreement, you're not required to stay with that company.
Can I apply the H-1B extension first time, H4 EAD and premium processing? Suppose already has an H4. If you're applying the H-1B extension, I'm assuming you would apply the H4 also, though. Even though she is on H4 already, and even though this is the first EAD application that the person is filing, you can file it together. They will adjudicate, they should adjudicate it together along with the H-1B.
Ram says, I'm an architect and was a reporting manager in India for 3 years and recently came to the USA for the same role, and the company is same. Am I eligible for EB1C? Potentially. Number one, we have to look at, does the company that you worked for in India have the right qualifying relationship with the company that you're working for in the US? And number two, when you worked there, was your position managerial in the eyes of the Immigration Service? And is the US position managerial in the eyes of the Immigration Service? The problem when you're a professional and also a manager is you may not be spending the majority of your time managing. So for example, if I'm the managing attorney at our firm, I am, yes, in charge of other attorneys and they report to me, but I'm also working on cases. And so I'm actually spending still the majority of time working on cases, preparing that product, not managing my direct reports. So you really have to look at what is the percentage of time that you're doing architectural work, assuming that you still are, and what is the percentage of time you're spending actually managing these people. And if you're spending the majority of your time managing, then maybe it would work.
I don't want to name the person, but the person has been rejected for the visa stamping for 212A2A small I. This is for the crimes involving moral turpitude. Can I apply for a waiver? The only way that you can apply for the waiver is that you have to prove that you are not a threat and safety to the welfare of the United States, and that a denial of the waiver will result in extreme hardship for the U.S. citizen or family members who are a U.S. citizen or lawful permanent resident. That means that if you don't have a U.S. citizen children or family members, that you are not eligible for the waiver at all.
Prithvi says the EAD was approved back in September 2022, but the card has been pending since then. What are the options? I think your best option is to refile, assume that you're never going to see that card, file again for the lost card, because the more time you wait for it, the less time you're able to work with that EAD. Your other options are service request, ombudsman office, or your senator or congressman's office. And you can do all of those as well, but I would also, as a backup, refile it immediately so that you don't lose any more time.
Question from Mama Pova. Is it possible to apply for I-140 in both EB2 and EB3 simultaneously with approved EB2 form? Answer is yes, you can. You can do both. Absolutely not a problem.
Minutecraft says, can I do a business on a business visa, B1, B2, or is it a green card a must to do business? This is confusing. Yeah, I think it all boils down to what exactly you mean by doing business. So a business visa is for you to come to the U.S. to negotiate contracts, to meet with colleagues, to meet with customers. Those are the type of business activities you can do in the U.S. on a business visa. But if you're talking about running a business that's based in the U.S. and you're in the U.S. on a business visa, you need a work visa for that. And that has to be sponsored by the business, which can be difficult to do. So that's why, yes, you might need a green card in order to be able to actually run a business, own and run and operate the business, versus just coming in for short-term business needs to carry out some activity of the business, but not actually running the business while you're in the U.S.
A question from Vani. I'm on H4 EAD, used to do stock trading in India. Am I allowed to do swing day trading here in USA? Absolutely. You can do it. You have an H4 EAD, you can do anything you want to. But in general, though, day trading, even if you don't have an EAD, you can do day trading. Since you have an EAD, you can do anything. I mean, any legal work, you're fine. You can flip a burger in McDonald's. You can be a CEO of Microsoft or Google. You can do any of those things. You're fine.
Jyoti says, I'm an L1B and it's expiring soon. And now I got a job offer from an H1B cap exempt medical facility. Will I get a fresh 6 years of H1B time, or is it just one more year? Only one more year. So the L1 time that you spend in the US does count against your H1B 6-year limit unless you've been outside the US for 1 full year before you make that switch. So yeah, if you've already used 4 years of your close to 5 years of your L1 time, you would only get 1 year of H1 time. But if you use all 5 years of L1 and have not spent 1 year outside the US, you're not able to convert to H1. So be careful to make sure you have some time left on your L1 to make that switch to H1.
Deepak Kumar's employer is going to file an I-140. His wife is an OPT. Can I put the details on the I-140 application? Will that cause any problem in the non-immigrant intention? As long as she doesn't travel outside the country, she doesn't have any problem at all. If she has any travel plans, I definitely would like you to discuss with a lawyer, but otherwise she's perfectly fine. You are obligated to put the information of your spouse in there, irrespective of whether you want it or not. And you also asked this question, can you apply for her H4 EAD and H4 without interrupting the job? Deepak, yes, you can. Once you get an I-140 approval, you can file the H4 plus EAD together. Don't file H4 and EAD separately, though. If you do so, though, then you are going to get the H4 and EAD approval 99% of the time at the same time. So in other words, she can, even though you filed the H4 plus EAD, she can continue working on an OPT or STEM extension if she has the validity. And when the H4 plus EAD approval comes in, she just switches to H4 EAD. So there is no interruption at all for her in the job.
Sarah says, if my H1 extension is filed and then the H4 is filed the next day, is that considered filing together? So will premium help get that EAD sooner? No. They have to all be in the same package, all delivered together on the same day to be considered concurrent filing that is qualifying for that fast process under premium. So I would not recommend that option.
How difficult is EB1A? Well, that's going to be a very tough question, though. I want you to watch the video that we made on the EB1A to see it's definitely not for Tom, Dick, and Harry. You must be extraordinary, some good skills. Now, does it need to be like you need to get an Oscar award or Nobel Prize? No, you don't need to. But in the particular skill set, what you are in, you should be good at it. I have one time done a EB1A for a person, really, that guy never wore his shoes in his life. He was working for a temple. He was making the molds for the temple. He could speak English, not that much, but in that particular field of making the molds, cement molds, he was the best in the entire world. And that too for the religious deities, though. So we were able to file. He didn't have a degree. He didn't have English speaking skills, and he was not sophisticated. And his whole family got an EB1A green card. So that particular skill set, he's very good at. So that's where people are looking into is that comparison to the other people. What is his qualification? Is he better than? Is he extraordinary? Or he's just a grade student? No, that's not enough. It has to be extraordinary. Of course, you'll have to qualify for the 3 of the 10 requirements. Now, my guy didn't qualify for the wage level thing because he was not making that much money. So there are other ways to qualify for this particular guy because he's not making $200,000 like you software guys were making. He was making very meager amount of money, but still he was qualified for EB1A. So it has to be in that particular skill set, you are the best.
Question, is it possible to apply for an I-140 in both EB2 and EB3 simultaneously with an approved EB2 perm? Yes, that is possible. It's 2 separate I-140 petitions, 2 separate filing fee checks, 2 separate sets of documents, and using the same labor certification for both. Any EB2 perm based on advanced degree or master's degree or bachelor's plus 5 years of experience should automatically qualify for EB3, and you can do both of those at the same time.
Teji has this question. Well, my OPT expires in June 30th. What are my options? I did not get selected in the lottery. Well, it's very tough to say whether you qualify for the H4 EAD, O1, and the EB1. I don't know. You may want to consider any of those options. People are asking the questions on the day one CPT. People are joining some other universities on day one. What's our opinion on it? Reddy Neumann PC takes an opinion that we don't endorse it. We have seen a lot of problems of the day one CPT universities. For example, University of Northern New Jersey. We have seen Silicon Valley, Tri-Valley University. Oh, not to forget the Farmington University. Some of these things are faked universities by the USCIS official. So that makes you understand really, let's say, for example, a government official is trying to trap you into doing some crime, for example. Will they try to come and tell you that they're going to sell you a Pepsi Cola, which is a drink that you drink, and if you buy it, will they arrest you? No, they're not going to do that stuff. What if they are going to tell you that they're selling the heroin or marijuana or something like that? So definitely the intensity of the USCIS is that they think so that the day one CPT universities are fake, that they are not legitimate. That's the reason why they are doing these sting operations. Like they do sting operations on the drugs. They don't do on Pepsi Cola. They never do it. Why? Even if it is definitely not a crime to purchase a Pepsi Cola from stranger. There may be some technical violations by the person selling the Pepsi Cola to you, but they won't do it. I guarantee that if somebody comes and tells you that they are going to sell you Pepsi Cola, they are not the sting operators. But if they are selling you like heroin or something like that, they can be, because of course, they want to do the sting operation. And they have done a couple of sting operations on the day one CPT. So that's not only that's the reason we have seen a lot of people affected with the other things like Tri-Valley, Silicon Valley University. So we definitely don't endorse it, but it's up to you guys what you want to do.
Raul says, it's been 6 months since my I-140 was approved and my wife got her H4 EAD recently. And he wants to know if in the future, if I change to a new employer, does my wife lose her H4 EAD status until my future employer files my I-140 again? No, she does not lose it. So she already has that valid EAD card. She can keep using that H4 and that EAD, even though you're no longer with that company. And she can keep using your old employer's approved I-140 to keep extending that EAD, just like you can use the old employer's I-140 to keep extending your H-1B beyond the 6-year limit because you've been with that company for 6 months after the I-140 has been approved. You also can retain your priority date when you are switching to the new employer in the future. So there's not a rush that you have to file the labor and I-140 again with the new employer unless your priority date is close to becoming current.
Can I extend the L1 if my I-140 is approved? No. L1 has a limit. If it's L1A, 7 years. It's L1B, it's 5 years. Even if you have an I-140 approval, you cannot extend the L visa.
Imran says, I'm selected in the lottery and also have a B1, B2. Can I be in the US and make a status change once the H-1B petition is approved? Potentially. So it depends. You have to have the B1, B2, I-94 valid through at least September 30th. So if the last time you entered, you got an I-94 that lasts through September 30th, then you could have your employer request a change of status from B1, B2 to H-1B when they're filing that cap subject petition that has to be filed before June 30th. But if your B1, B2 is expiring before September 30th, you're not eligible for the change of status because your status doesn't last long enough to get you to the October 1st start date of your H-1B.
Question with regards to any latest updates on the visa recapture bill. I've been reading about that visa recapture bill where we're going to get the extra green cards though. This has to go through the Congress, which the parliament they call in USA Congress. It has to go to the parliament. It doesn't look like we have enough votes at least to pass this one in the Senate because we need 60 votes to pass. So I don't know whether it's going to be passed. At this point of time, I would give less than 5% chance that it will be passed through. That's the reason I want to put more pressure on the administration. Instead of going to Congress, which we have been trying many different ways, the high-skilled labor thing, where increasing the green card numbers, a lot of different times we failed. What my advice to the administration, which I want to have your help in advising the administration, is that forget about the Congress. Why don't you do one thing? Stop counting the family members of the employment base. If you stop counting the members, it automatically goes from 140,000 to 300,000 green cards. And that is for every year. I mean, we want to remove the per country quota limit, we have to go to Congress. We want to get the recapture of these things, we are going to the Congress. Going to the Congress is not helping. It's just a pretension. I know Raja Krishnamurthy is a very nice congressman. I met him a couple of times and he's a very nice guy. But sometimes what they do is that they want to please their constituencies. They just want to please. They know it's not going anywhere. So that's how I look into this bill at this point of time. But if there is any traction that comes in, we will let you know at that point of time. We will tell you to write letter to the congressman. But at this point of time, I want you to use the energy to contact the administration to not count the family members. The link is provided. Please use that link.
Another question that came in is, why is the perm process taking longer these days? I think there's a number of contributing factors to that, but one thing to remember with perm is there's no filing fee for it. So they're basically being funded by Congress, Department of Labor's funding. And so they only set a certain amount of budget. So they have a certain amount of money they can spend on officers. They have a certain number of officers. That doesn't change even when the number of applications being filed goes up. And then on top of that, we had COVID. We had the October 2020 visa bulletin that caught a lot of people off guard that had just changed employers. And so they're saying, hurry up, file my perm. So we were filing so many perm applications because the dates moved and people were finally seeing a light at the end of the tunnel. Then we have the Trump administration trying to change the prevailing wage calculation. So everybody hurried up and filed prevailing wages under the old rules so that they could get them in before the new rules took effect. So we have a bunch more prevailing wage requests than normal. Then that rule got eliminated through litigation. And so the Department of Labor had to go back and reissue all of those prevailing wages under the old rule. So just all of these things are contributing, and there's just more and more labor certifications filed. And there's not more officers to handle that additional work. So all of that is contributing to these long processing times.
Question from Shailaja. Can somebody work on 2 jobs on H4 EAD? Absolutely, you can. You can work on 2 jobs. You're good. Premnath has this question. USCIS moving dates of EB3 and EB2 without any knowledge. Now EB3 is head of EB2. If we start downgrade again, doesn't it pull back the EB3 to do it again? Yes, you're right. You're right, Premnath. That's what happened when they published the October visa bulletin in 2020, which they did in September, that they really did not have any clue. Now, did they learn from their mistake? Did they understood it? Did they know it? I don't think so. Yes, this particular people moving to EB3 to EB2, EB2 to EB3, it is really frustrating. But unfortunately, at this point of time, you don't have an option. If people are on EB2, it's not current in EB3, I would strongly recommend that to file an I-140 in EB3 and then probably try to take advantage with the EB3 prior to date. Yes, Premnath, you're right. Later on, what if the EB2 moves? Well, you do it again. Unfortunately, there is nothing else that can be done. People are asking me to project the EB1 prior to date moving. I've been very wrong in projecting the prior to date. The only thing I was right in projecting the prior to date was that I told that EB2 and EB3, because of the mistake what the USCIS and the State Department did, sometimes EB2 will move forward, sometimes EB3 will move forward, very similar to that Los Angeles highway. Because everybody's trying to move to the one which is empty lane, the one which they moved becomes empty, then people try to move this one, and the same thing is happening. But with regards to the prediction, I'm very wrong. I've gone very wrong so many times. But yes, Premnath, you're right. EB2 and EB3 will go on. People will move to EB3, and then again, EB3 will backlog, and then EB2 will move forward. This is going to continue to happen. For the next 5 to 10 years, it's going to continue to happen. That's the reason why I want everybody to write letters to the administration to not count the family members so that we all can get the green card and happily live ever after.
Kamlesh says, once the 485 is moved to NBC in the EB1 category, how long is it taking for them to be processed? Been waiting for 19 months. Yeah, that's quite normal. There's just no urgency anymore. You know, when we had all of these extra green cards, USCIS finally started getting their act together and processing them quickly. Well, now that we're into the next fiscal year, they really have until September 30th to approve all of the green cards, and they're just taking their sweet time. And the processing time, you know, there is no listed processing time for NBC. You have to look at what is your local field office for their processing time. And I know here in Houston, it's still listed as 24 months, and that you can't do any kind of inquiry if it's less than 24 months. I think that's ridiculous. They clearly can do it much faster than that, but the only thing you can do is litigate it, which we have been doing, and that's been quite successful. So that's something to consider if you're tired of waiting on that.
Amit Indoria has this question that he's unable to get the non-availability of birth certificate. What are the options? First, you may want to consult a lawyer. Though. The reason is that first we need to know why you're not getting the non-availability certificate. Could there be alternative sources though? We need to give an explanation nowadays. Previously, they used to allow us without non-availability certificate by providing the Aadhaar card, PAN card, ration card, election card, and other things, school certificates, and hospital records. They used to allow us, but nowadays they're very strict on this non-availability certificate. So we need to give a solid reason why. For example, that particular municipality does not have the non-availability certificate. That particular gram panchayat does not have the non-availability. If we can get an evidence of that, that may be a better option though. But yeah, you have to discuss with the lawyer on that because that has become a must nowadays to approve the green card.
How long is it taking to get the I-485 EAD application once it's filed? It is all over the board. I've seen some getting approved in just 2 months. Others are taking 6, 8, 10 months to be approved. There's just no rhyme or reason to it. It seems like the more recently filed ones are getting approved quicker, and the ones that were filed earlier are still pending.
Questions with regards to the how long it's taking for the EAD for the adjustment of status. It's taking anywhere between 4 months to about 8 months for the people to get the EAD in the adjustment of status.
Premnant says, can we write a letter to USCIS to act in a proper way in moving EB3 and EB2? We keep on writing letters every week. Can we just add one more? Well, the thing to be aware of is USCIS doesn't have anything to do with it. It's the Department of State. And so there's, they're looking at the data that they're seeing. All they're seeing is what's in the pipeline at the consulates, and then they have to rely on what USCIS is seeing in their pipeline. But a lot of the difficulty is until someone files a 485, they don't know how many applicants there are out there. They know they have this many number of approved I-140s in EB2 and this number in EB3, but they don't know exactly how many family members are always going to be included in those. And a lot of people have multiple I-140s, so they're just kind of shooting in the dark. But it would be the Department of State that we would need to be contacted to. But this flip-flopping between EB2 and EB3 is definitely not anything new. It's gone on for many, many years. It's not been common for India until more recently, but China has been dealing with this for a number of years, so it's not really a new problem.
This question is coming for the Santosh Nair. I want everybody to listen very carefully. He has a H-1B stamped with company A, which is expiring in July 15, 2023. And he's going for a drop box with the company B. Will there be any problem because his visa is not expired for stamping? The answer is no, that will not be a problem. Actually, Santosh, if you are going to India, you don't have to even go for the drop box. You could have just come back before July of 2023 and show them the company A's visa stamping, but tell them that you're working for company B. Show the I-797 of company B. That is allowed, but it's not, you don't need to go for stamping, but if you are going, it still is not a problem.
Dennis says, can one work as a physical therapist on F1 OPT, where they're US trained, without a visa screen? And is the visa screen required for H-1B and AOS? Yes, so you can work on OPT without the visa screen. Your OPT allows you to work for any employer. So as long as you have the license to work as a physical therapist in the state where you'll be working, you have all you need in order to work on OPT. The H-1B, you're correct, it does require the visa screen at the time you receive either the change of status to H-1B or at the time you apply for the visa at the consulate. And then the same thing for the adjustment of status for the green card. You either need it at the time of filing the 485 or when they send a request for evidence asking for it. But for other visa categories like F1 OPT, it's not needed.
I mean, is there a different process for the green card for physical therapists? That's what I heard. Can you explain that more?
Yes, it's called Schedule A, and the benefit of Schedule A is the Department of Labor has decided, because we have so few nurses and physical therapists in the US, that they have predetermined that there's a shortage, and they've pre-approved the labor certification, basically. So you skip the entire perm labor certification process. Now, the employer still has to get a prevailing wage, which is taking 7, 8, 9 months to process. They still have to post a notice of filing to inform U.S. workers in the area of employment that they plan on sponsoring someone. But then they take those documents and go straight to filing the I-140. And then if the priority date happens to be current for the country of birth, they can also file the 485 along with it. So you definitely can cut out probably a good 12 to 18 months of processing time by skipping that labor certification process, and it's called Schedule A green card.
Anything else, Emily, before we close?
I think we are out of time for today. Remember, we are having our webinar on options. If you're not selected in the H-1B lottery, we'll go more in depth on all of those available options. So you can find the registration link in the comments, or you can go to our website at rnlawgroup.com to register for that, and we'll be having that on Thursday.
Thank you very much for tuning in. We'll be seeing you next week.